Hey everyone, welcome back to News BLADI. Today, the DOJ has dropped a surprise that completely shook social media. New statements have emerged from inside the grand jury connected to James Comey, and they're taking this case in a very serious new direction. What exactly was said? Why now? And how is the White House responding? Stay with me. We're breaking down the full story.
Breaking news in our law and justice lead. Moments ago, the Justice Department responded to a bombshell revealed in the case President Trump's handpicked U.S. interim attorney Lindsay Halligan brought against former FBI Director James Comey. There was silence in the courtroom when Halligan revealed she never presented the charging documents to the full grand jury. The judge also said the case is, quote, too weighty and too complex to rule today. Now, remember, all of this stems from an accusation that Comey lied during a 2020 hearing about whether he authorized leaks. Comey believes this is all about Trump being vindictive, that the investigators have mishandled the case, and he wants the charges dropped. Joining us now is CNN's Caitlin Polentz and former U.S. Attorney Harry Litman. You were both in the courtroom today for this, I think it's fair to say, bombshell hearing, right? You said you were gobsmacked earlier. Yes. Before we get into all of that, what did the Justice Department just say moments ago?
Yeah, so they filed their explanation plus some other arguments, and they say, it's fine, it's normal, nothing to see here. They say that what happened that was said in court today revealed that there was only one charging document that the grand jury was presented with, that they deliberated for over 2 hours, and then there was some changes made to it by the prosecutor, removing one of the charges but keeping the two that the grand jury would have been in support of. They say, yeah, that is exactly what happened. I'll read a little bit more from what the prosecutors are writing now in explaining this to the judge. They say, this was not an unusual series of events and is fully explained by the U.S. Attorney's declaration. That would be what Lindsay Halligan has said already. The court reporter's recollection, the grand jury coordinator's discussion with the grand jury foreperson, and the grand jury foreperson's explanation in court. They also say, there's not an issue here, quote, is not an issue. The transcript is complete, the procedure was proper, and no aspect of the record supports the magistrate judge's assumptions. This is all about whether Comey's team can build their case that there were things handled inappropriately with the grand jury. And they say, no, that's not correct. And you should not allow Comey's defense team to get access to grand jury transcripts. Comey's team, of course, will have a chance to respond. That is expected by the end of the day Friday.
And just for our viewers to understand, because this is, we're legal nerds, right? But so basically, it came out today that Lindsay Halligan did not show the full grand jury this indictment, the final indictment. She had the foreperson sign off on it. I'm wondering, as a former U.S. attorney yourself, how unusual this is, because DOJ is saying nothing to see here. But I mean, is there something to see here?
Hallie's comment, more unusual than that. Never, ever, ever have I or anyone I know ever seen anything like this. And remember how it came about. They were trying to figure out, what did she do? Because she said, I never talked to the grand jury again. So when did she approve that second indictment? And the answer, it turned out to be, in open court, and Nachmanoff had her come up to the podium, was never. She had never, the grand jury never even looked at the actual indictment that is operative in this case. Absolutely unprecedented violation of many rules, etc. And Ken's totally right about what they're saying, but they are acknowledging the sort of 11 violations that Fitzpatrick found and more, but they're saying, nevertheless, you can't give them the information or you can't dismiss. But they're basically acknowledging some huge and, as I say, unprecedented kind of blunders.
And you've been talking, Caitlin, to people connected to Halligan's office. It sounds like they're not so sure how this is going to play out.
Yeah, I mean, the way it landed in court was like this was a thud that everyone took a minute to react to. Even the judge, he was clearly, he just didn't know how to react. He went silent. He sort of sat back in his chair and then had the prosecutors repeat that this was indeed what happened with the grand jury. But the people that I talked to after the hearing, there's a mixed bag. There's not really case law on this. And, is this a clerical error? Is it something that they could correct as prosecutors? Maybe. It isn't something that has gone up through this court system. However, the issue that the magistrate judge has been looking at is whether there was an irregularity in the way that this came about. Did the prosecutors mishandle a bunch of things? Evidence, the presentation to the grand jury? Did witnesses, the agent that testified, say something they weren't supposed to be talking about, the evidence that they had seen? Should they not have seen that? Did the prosecutor do something where she said something wrong to the grand jury? This plays into that. That's why it matters.
Just take it a step back really quick, and I want to let you weigh in. We have to go back to that infamous Truth Social post that was then taken down when Trump addressed the Attorney General Pam Bondi, saying that Lindsay Halligan was great and, quote, "we can't delay any longer on Comey's indictment." So with that context in the background, and now learning that instead of just bringing the final indictment back to the full grand jury, she just had the foreperson sign off on it. What story does that tell you?
Right. And that had been the focus until this gobsmacking moment of she did what? But you're absolutely right. And the claim by the United States was it was still 100% Lindsay Halligan's decision, even though she only had 3 days to make it. And the defense claim was common sense, give me a break. Obviously, it flows causally from what Trump did. That had been the whole skirmish until this Perry Mason moment that, happens in movies, but not in real life, where it turns out the grand jury had never even seen the indictment in the file.
But does it signal to you there was a rush to
There was a rush because of the statute of limitations, and they rushed her in, and that's going to matter a lot too, because that's an extra element here. If it's dismissed, can you nevertheless sort of relate back to the statute of limitations? Nachmanoff will have to give them a lot of breaks in order to let them slide here. And remember, he could first and foremost just say, vindictive prosecution, case dismissed, end of story.
All right, we shall see. Harry Lippman, Caitlin Polantz, thank you both. Appreciate it.
Jeff, good to see you again. So when we look at this revelation from Lindsay Halligan, and the judge, of course, has the questions, wants these answers by 5 o'clock, just put in perspective for us, how serious is this?
Okay, I think this all started when the judge asked a question about a declination memo, and the assistant attorney general refused to answer the question because he had been instructed by Todd Blanche's office not to answer that question. That's when I think the judge decided to dig in with the question he had been waiting all morning to ask. And that was based upon the order that was entered a few days ago, that in fact there was this long 2 hours where they were doing things and there were 2 different indictments. He wants to know, how did you get the jurors back in the jury room to look at this second indictment with only 2 counts in 7 minutes? How did you do this? And all that turned out was, all that happened was that Lindsay Halligan took it to the foreperson and one other person and had them sign it. Those jurors never voted on the second indictment. So therefore, there was no indictment. And if there was no indictment, Comey wasn't charged. He wasn't charged, the statute of limitations ran, and the case is over.
And this is over. I do want to, I wanted to ask you about, so you just brought up the other moment in court, which, as you said, sort of maybe allowed the judge to then open himself to this line of questioning to ask Lindsay Halligan about that specifically. But the fact that the lawyer for the DOJ, so Tyler Lemons, had declined to say whether prosecutors submitted this memo that recommended Comey not be prosecuted. So he eventually told the judge that it was someone in the deputy AG's office, as you know, to Todd Blanche's office, who had instructed him not to say anything. When it comes to a direction like that, is that type of direction to not testify about something, is that standard operating procedure? Would that normally happen?
No, that really wouldn't happen, because the essence of what's happening in the motion itself is that, in fact, the DOJ, through the other representatives that handled this case, said no charges here. And it was in those last few days that the rush took place to get Halligan in place. What we saw was the crossroads between arrogance and ignorance. And they both crossed. Halligan being the ignorance, arrogance coming out of Pam Bondi and Todd Blanche. And they crossed at a very crucial point, and there's no cure for it.
You point out, too, which is important to note, the statute of limitations was running out, has since, right, but did not when it was first handed down. Yeah. I'm curious, this is not the only issue, of course, that we are following in terms of James Comey's indictment. Just a couple of days ago, a federal magistrate judge, this was in the Eastern District, said that the indictment may actually be tainted by, quote, profound investigative missteps. That finding was focused on the evidence of the case. How does this
Right.
reflect
Right.
on Halligan's prosecution of the case?
Well, first of all, Halligan had no business handling this case. She worked for a insurance defense firm in Miami called Cole, Cassane and Scott. And Mr. Scott is a former a U.S. attorney, and he's a former district judge. And she had a source to find out information if she didn't know what she was doing. She didn't know what she was doing. And the big key to that is when she told the grand jurors that Mr. Comey had no right not to testify at the trial. I mean, I don't know who taught her criminal procedures, but I think the Fifth Amendment is still in place in the federal system that says you can't be forced to testify.
It is
I don't know where she was going with it.
When we look at all of this, the Fifth Amendment kind of important to Americans. When we look at all of this as it's playing out, there are also questions about whether the findings here could in any way impact the case of another political adversary of President Trump, the New York Attorney General Letitia James, also being tried in the Eastern District of Virginia. Any overlap?
I'm not sure because I don't know if they considered both indictments in the same day. But let's assume for the moment that they didn't. Then you'd have to look independently at the charges involving Atish. And the truth of the matter is that I think that even if that fails, it would be a technical flaw on her indictment. Her statute of limitations is nowhere near running. They can go back to the grand jury and try to do it again. That's the difference between the two of them. Comey was 3 days from the statute of limitations running, and they don't really get a second bite at the apple if they lose this indictment.
Jeff Swartz, appreciate it. Thank you.